Good morning. Welcome back to the Retirement Report. I'm Hank Parrott, your host. With me, my good friend and special guest, Russ Cook with Russ Cook and Associates over in Brentwood, Tennessee. And we've been talking estate planning. And just for the break, Russ, you were going to dive in about, and there's a good point you're about to bring up about we were talking about divorce. Specifically, if you set up a trust and you want to protect your children, all right? We're talking about having your IRAs and retirement plans. You can't put them actually in the trust. In other words, you can't change the title of them because that would be a taxable event. We don't want to do that. But we do name the trust as the beneficiary. Sometimes maybe even a contingent beneficiary, depending on the kind of planning that we're doing. And we'll talk, we can possibly get into that. But one of the things when you're leaving it to your children, then instead of having the IRA go direct to the child as an inherited IRA and they lose the asset protection features that they could otherwise have, and potentially risk losing out on being able to stretch out the distributions over their lifetime, one of the things that you do is by leaving it to them in trust instead. They still control it. They can take out as much as they want. They still can do whatever they want there. But now they've got, it's like putting it in a safe for them and giving them the combination. They're the only ones that can access it. Well, one of the areas there then, that we're looking at for asset protection features there is if they were to go through a divorce, this is a great way to protect those assets for them. So even if they, half of whatever else they had goes away, at least this asset is kept for them and for your grandchildren, of course, as well. And Russ, you mentioned a good point, which is with divorce, a lot of times people don't think of maybe circling back around after the divorce and changing all the beneficiary designations.
Yeah, a lot of times people think that when they sign those final divorce decrees, and this would be for the clients that we have in our office that own IRAs and 401ks, that those divorce decrees somehow X out the ex-spouse, but they don't. You actually have to go back in and redo those beneficiary designations and make sure they go to the kids. And that's the same if you get married. If you get married, and you want it to go to the kids, not the surviving spouse, you want to go back and redo them, because a lot of those plans will default to a new spouse, even though your beneficiary designations may say something different. And the other thing, to piggyback on what Hank said about naming a trust as a beneficiary instead of a child, there is the issue of pause. A lot of times we find when a child receives paperwork from an IRA or 401k custodian asking them to make an election, they elect lump sum distribution, not knowing that now they've created an income tax issue to themselves. If the beneficiary designation is to them as trustee of a trust or to a trust, then they have to say, okay, maybe I need to get advice on this. And they do, and they make the better choice. So just food for thought in making those decisions. And
think about that part about the beneficiary designation. Russ, we've had experiences with clients over the years where someone coming in usually, but I mean, you get the stories where they didn't make that beneficiary change. You've had that kind of
Yes, yeah. In fact, it's been embarrassing because nobody ever thought that the ex-spouse was still on the retirement accounts, and then when you're administering the estate, you have to break the bad news to the new spouse, who now realizes that the largest asset is going to the ex-spouse, and there's nothing she can do about it. And it could cause additional costs and expenses too. In that case, there was a tax associated with it that had to be paid from the estate. So the new spouse lost out on the beneficiary designation and then had to pay the tax on the transfer. So that's something you don't want.
This is one of the areas that in doing a team approach and working with Russ, one of the areas with my clients, when they go meet with Russ and we're doing up an estate plan, I attend those meetings as well. And then when Russ gets everything set up and gets real estate transferred in and does all the documents, I make sure that I'm aware of what's happened now. I know what the plan is, and I know then to make sure that the other assets and the other accounts are, that the beneficiary designations are set up, or that accounts are transferred into the trust as needed. All that stuff we make sure with my clients that's a seamless process, because we're working together throughout it. And this is the other piece with, Russ, when you get an estate plan set up, typically you might see a client maybe after 5 years or something. It's usually a lifetime type plan. I know you are really good about sending out letters and saying, hey, you know, do you need to sit down for a review and stuff, which a lot of attorneys don't. You get that document, right, and it's 10 or 15 or 20 years later even, and you've never even, you know, had a contact with that attorney again. Well, one of the things with it, you know, which if you've got a good financial advisor, we work with that, all right? So with my clients, I meet with them 2 or 3 times a year. So we're always in the loop in terms of things that are, if anything's changing, as I mentioned earlier, about their accounts, to make sure that those beneficiary designations are taken care of at that same time, so we don't have any unpleasant surprises. We make sure that that's taken care of up front when we first set up the estate plan, and then it's kept up to date over the years as well. And so far, you know, that's one of the areas when we get together and when someone has passed and we're administering things, it's been one of the reasons that we can say, yes, it's going to do what we've intended it to do, because that's one of the areas we've kept up with. You know, one of the other areas that Russ talked about, and this is relatively new, the community property trust. Why don't you talk a little bit about that, because that's what, just again in the last few years that those have become available? Yes,
and it's really an amazing tool that we have here in Tennessee. Community property is effective in some states, not Tennessee. I think Texas, California, community property states. And basically what the federal government says is if you own an asset as community property, husband and wife, when the first spouse dies, you get a full step up in cost basis on those assets. Now, Tennessee did not have that benefit until they decided to pass what's called the Community Property Trust Act, which basically says that a husband and wife can create a joint revocable trust. They can control the assets inside it as co-trustees and co-beneficiaries, and at the first death, we get a full step up in cost basis on assets inside the trust. So for example, even if, let's say you have a home and you know that you have a capital gain exclusion of $250 if the survivor tries to sell it. Well, what if the home's worth more than that, or the capital gain's more than that? What if you have investment accounts that have capital gains? I mean, you can have as little as 20 or 30,000 of capital gains, and if you sell, you're looking at capital gains tax at 20% of that, depending on your tax bracket. A lot of clients have investment real estate, whether it's single-family homes or farms or whatever, that they don't even know what the cost basis is, especially if you've inherited it through generations. Well, this is a way to reset that and give the surviving spouse some latitude in being able to sell. And then if we structure the plan right, we can also get a full step up in cost basis at the second death through the same sort of trust arrangement. So
for both the surviving spouse and then the children, of course, would benefit as well.
Exactly. Yeah, exactly. So especially when you have assets of that type, you want to look to this trust because it does offer benefits that you wouldn't get with a will.
Right. So this is one of the areas that, you know, again, understanding how you can apply these strategies in your situation and get the benefits there. Again, who's losing out here, right? The IRS. You're not paying as much tax. Is that a bad thing? Not for me. I hope not for you. All right, we're going to take a break. When we come back, you know, one of the areas about estate planning, we're just talking about capital gains taxes, income taxes. There's a lot of different ways that good estate planning can help you with regard to taxes. And of course, it goes into your financial planning as well when you're talking about taking money out of retirement accounts, how you can minimize taxes there. We'll talk a little bit about that too. So join me here. We'll be right back on the Retirement Report.